Employment Rights Act, the soonest change is statutory sick pay from the 1st of April. So at the moment, I think we're all aware that it's only if you're continuously off for more than 3 days. So from the fourth day onwards, you get paid SSP, and you have to earn over the lower earnings limit, which is currently £125 a week, to qualify for SSP. From the beginning of April, that is no longer the case. It is a day one right. That means the staff do not need to earn over £125 a week to qualify. They qualify no matter what they earn in a week. If they are not over the lower earnings level, then they will receive 80% of their weekly earnings. Now, all of you have either got payroll software yourselves, or you work with people who have payroll software that will automatically update with the amounts in there. So you don't need to worry, and you shouldn't be doing manual calculations on this. The key takeaway, though, is that everybody in the first week of employment onwards will be entitled to sick pay if they go off sick, no matter what contract they are on. And they haven't changed the fact that it can be paid for 28 weeks. So you need to be looking at the sickness in all employees. Are there people who are regularly taking 1 or 2 days off? Those are the people we need to start tightening up the procedures on. So everybody who goes off sick should have a return to work interview with their line manager going, why were you off? From an employment law perspective, making it slightly uncomfortable for them, not unpleasant, but uncomfortable, that they have to justify why they were off. They can't get away with, I just didn't feel great. Okay, tell me more about that. How did you not feel great? If they've been faking it, they might well make up something the first time. The next time, one, they're either going to be really much more convincing and have thought out their lie in advance, or they're not going to do it quite so quickly. Okay, and they're probably going to use holiday or time off in lieu. The other one that has been confirmed is the unfair dismissal. So at the moment, employees are not protected from unfair dismissal. Unfair dismissal is the legal term, not the moral or ethical term, the legal term for the first 2 years of employment. That is changing from the 1st of January 2027 and will apply to all employees employed at that point, not employees going forward. Everybody you have on your books as of the 1st of the 1st has the protection from unfair dismissal from the first 6 months of employment. You are going to need evidence that you have done your duty to train them, to retrain them, to show them what they're supposed to be doing. And if there's problems with attitude, that those have been addressed. So what we're suggesting, and we're going to do this in the contract templates for everybody, change your trial period, if it isn't already, down to 3 months, so that if you need to extend it, you still have a good 2 months to extend it before you get close to that 6 months. We are recommending that you do weekly review meetings in the first month, where you have Firefly's AI, there's an app on your phone, listening to the meeting. Officially, it's not secret. And then they have a summary of what was agreed, and they give that via email or WhatsApp message to the employee. And then they have a record of what's been agreed, what's going to happen, what training is going to happen, what the issues are, what the employee said they would do, as well as having the transcript if we need it.
Thanks for watching. If you want a free peace of mind call with us to discuss your policies, handbook, and any burning staff issues in your business, click the link in the description below.